The House has before it House Bill 1187, which has been read. Mr. Chief Clerk.
Mr. Speaker, engrossed House Bill 1187 was introduced by Representative Kempenick and other House and Senate sponsors. Engrossed House Bill 1187 is a bill for an act to create and enact a new section to Chapter 38-01 of the North Dakota Century Code relating to orders of the Industrial Commission. Mr. Speaker, this as a fiscal note prepared by the Industrial Commission. Their analysis indicates that they are unable to determine any fiscal impact. Mr. Speaker, your Industry, Business, and Labor Committee recommends amendments which are passed on the previous sixth order. When so amended and engrossed, recommends do not pass on engrossed House Bill 1187 by a vote of 7 yeas, 4 nays, and 4 absent not voting. Mr. Speaker.
Representative Lanning.
Thank you, Mr. Speaker. Mr. Speaker and members of the Assembly, your Committee on Industry, Business, and Labor recommends a do not pass on HB 1187. This bill, as introduced and as amended, would void any Industrial Commission orders that may be viewed as rules of general applicability unless they had gone through the full rulemaking procedures as described in North Dakota Century Code, Chapter 28-32. The issue debated applied primarily to oil field activities and what is generally referred to as field rule orders issued by the Department of Mineral Resources. Our committee had considerable discussion regarding the impacts these field rules may have. 2 orders specifically from 2014 were identified as having a significant impact regarding the capture of natural gases and crude oil conditioning prior to rail shipment. The Commission testified that although the 2 orders in question did not go through a full rulemaking process, each of them underwent an open hearing process to allow stakeholders the opportunity for input. The Commission further testified that the flexibility of their present process is necessary to allow them to regulate under the many varying factors they see all the way from Bowman to Watford City to Bottineau. They also felt the orders utilized should not be considered under any general applicability provisions, since out of the nearly 3,000 well sites overseen by the Commission, the 2 rules under discussion only applied to 426 of them. The Commission also feels their ability for a rapid response to situations such as crude oil conditioning or oil site environmental issues is very important to their ability to function and protect the public safety, as well as to deter interferences from various federal agencies who would be more than happy to insert themselves into our oil field activity. Therefore, Mr. Speaker and members of the Assembly, after considering all of the testimony and the necessary response times needed by the Industrial Commission, your Committee on IB&L recommends a do not pass on HB 1187 and request your concurrence. Thank you, Mr. Speaker.
Is there any discussion? Representative Kempenick.
Thank you, Mr. Speaker and members of the Assembly. Well, you heard the executive branch's explanation of this bill. I think what this bill is trying to do is exactly that. There is a process. There's 3 branches of government in this country, and when you get broad policies like this, you start running into issues. This isn't something that should be taken lightly, members of the Assembly, because as you take, this becomes death by 1,000 cuts of what this Assembly is here for. If it isn't broad policies, and this is not only oil field, this started last winter with Special Places Initiative, and that is a policy on the Industrial Commission's books, that once you start, and that policy originally started on the takings of private land, and this process of administrative rules process is a watered down process of this Assembly right here to start with, that if they can't run through and have general on orders, if they can't make rules that are broad enough and have orders within the rules, then there's something wrong with this, the way this works. I think that anytime government starts moving fast, somebody's going to take the short end of the stick. And this here is a process. It's not prohibiting anything, but it requires that they run through at least a process that the legislature has put in place for broad policy initiatives outside of the rules that we give the executive branch. I think that this body should consider that. You got to ask yourself, why are you here? Because it is something that becomes, really does become a separation of powers within these institutions. Thank you, Mr. Speaker. I hope that we get a few green votes on this.
Is there any further discussion? Representative M. Nelson.
Thank you, Mr. Speaker and members of the Assembly. I really have to agree here with Representative Kempenek. The reason, even the Industrial Commission is realizing that they're overstepping their bounds, because that's why they're taking this public input and everything. They're taking a mirror or a weak image of what we require under the law. And they're kind of doing it and then say, okay, forgive us for breaking the law, because we kind of followed the law, we just didn't really follow the law. And if we want to, our law doesn't say every person in the state or every area in the state has to be involved before you have to go through the administrative rules process. This is actually, just hitting a few of the highlights, so to speak. We could pretty this up. We could make it where if they're in the administrative, or if they have an order and they're in the administrative rules process, that order could stay in effect until they've completed the process. We can make this work. But they should not be able to make rules that we, under the law, say have to go through the administrative process without going through the administrative process. Please support this.
Is there further discussion? Representative Kaiser.
Mr. Speaker, members of the Assembly, just a little bit of background, and I would certainly stand to be corrected on the floor, but the administrative rules process is a process developed by the legislature to examine and consider rules that are adopted by agencies as they take laws that we have passed, and to make certain that the laws that we have passed, when they are not specific and agencies develop administrative laws to implement the administrative rules to implement the law, then we do take it back through the administrative law review process, and that committee simply looks at the rules that have been written to make certain that they conform to the law that was passed by this legislative body. Orders are an entirely different issue. Orders are a regulatory issue, and the Legislative Assembly does give to various departments within our state the authority to regulate their industry. The Health Department can issue an order. It can be very quick, or they can take time to deliberate to determine what the order can be. They can have hearings, but they also can do it on an emergency basis. Obviously, the energy area has the authority to issue an order relative to any problem that might occur out there. These orders are outside of specific legislation. They don't fit the administrative rule process as it has currently been designed. The Insurance Department issued an order during the interim wherein they joined with several other states on a lawsuit relative to unclaimed property, and the state of North Dakota received several millions of dollars from insurance companies. These are regulatory orders. We have given them the authority and the responsibility to regulate their industry. Yet they are general orders. Representative Kempenek is absolutely correct. But they are not the direct administrative rule written from a law. So how do you write an administrative rule for an order that you're initiating? And what do you review it against? The committee had a considerable discussion on this issue, and we certainly hope that we maintain the authority of agencies in our state, including the Oil and Gas Division, to regulate this industry in a manner that they deem to be appropriate. Certainly, if we don't like it, we can change it in law specifically, make specific changes in the statute, but these are not strangers. They're not people that live outside of our state that are engaged in the regulation of these agencies. These are our people, our team, and they are trying to do an excellent job, and I hope you support the recommendation of the committee.
Is there further discussion? Representative Scarpel.
Thank you, Mr. Speaker, members of the Assembly. I'm going to support the committee's recommendation, but I also agree with Representative Kempenich. I believe there's some middle ground here that we're neglecting, and that is that, we can allow these agencies to do their regulatory jobs and issue orders, but there ought to be those provisions in the law that when that order gets to some level, it should have to come back to the Legislative Assembly in the next session for review by this body. I agree with that. I think that's important. That order would therefore be more likely to be of a nature that was reasonable because it would be subject to us. So while I don't think this bill is the answer, I would not be surprised if I was here as a freshman as you don't see this issue again in some form of amendment later in the session. Thank you, Mr. Speaker.
Is there any further discussion? Representative Kempenich.
Mr. Speaker, and I just forgot to add one thing. This body sometimes is held in contempt by other interested parties across the state. One of the larger newspapers in the state called this process a legislative sideshow. So, like I said, members of the Assembly, you got to realize why you're here.
Is there any further discussion? Seeing none, the House has before it for final consideration House Bill 1187. The clerk will open the key and you may record your vote. Has every member voted? Does any member wish to change their vote? Key will be closed and the clerk will take the record. The final vote shows 61 yea, 27 nay, 6 absent, not voting. House Bill 1187 is declared passed.